there, Whitney Emanuel, welcoming you to our video series on estate planning and estate planning documents. So the first thing that I'm going to talk to you about are the basic documents that you will likely establish with every estate planning attorney. They are your will, your power of attorney, and your healthcare directive. I'm going to explain what each of these accomplishes in your estate plan. So a lot of people think you have to have a lot of money in order to do estate planning. However, these three documents are relevant to everybody, regardless of the amount of money that they have. And the reason for that is because the second two, the power of attorney and healthcare directive or healthcare proxy, refer more to your health and if you become incapacitated, but still a part of your estate plan, right? And so I'll actually dive into those first. So a power of attorney, what this is a individual or individuals that you appoint who can make decisions on your behalf if you are, like I had mentioned, incapacitated due to a medical issue. Maybe you're in treatment, so many different things that could happen, or you're out of the country and you cannot pay bills. You cannot get information that's important in order to make changes to your bank accounts, to pay medical bills, etc. So this power of attorney would do those things on your behalf. It must be someone that you trust. Otherwise, this person could take advantage of you if you've given them that legal right. And so a power of attorney is really important. Most power of attorneys are durable, or should, at least in my opinion, they should be durable, meaning that they are enforced, especially when you are unable to make those decisions physically or mentally. There's a springing power of attorney. This is an interesting one that actually only goes into effect when you are incapable of making decisions, mental incapacity or physical incapacity. So that's the power of attorney. Then you've got healthcare directive. Healthcare directive is appointing a person to make decisions on your behalf as far as how you want to be treated medically. Do not resuscitate or resuscitate, those types of things. Whether or not that you would, if a machine is helping you breathe, for example, do you want it unplugged after a certain period of time? So you can have those wishes written down, or you can appoint a person. That's what most people do, just because there is a lot of nuance in there. Oftentimes, the power of attorney and healthcare directive would be two different people. One, the person good with money, one, the person good with health decisions and emotional decisions like that. Lastly, you've got your will. So this is something that really provides instructions on all your assets that go through probate court. If you have a solid will with solid wishes, it's okay to go through probate court, for your estate to go through probate court. And what that will does, it appoints an executor of the estate. So that would be the person who settles everything on your behalf after you've passed away. Oftentimes people have the power of attorney and the executor of the estate be the same person. Again, I have a lot of clients that have a will and they don't have a trust. You may have heard that going through probate court is bad. It's only bad if your will is not written appropriately or according to your wishes, or if you don't have a will. You still have probate court if you don't have a will. So what the will does is organizes probate court and establishes their wishes, and the executor follows the documents that you put in place. So those are the three basic documents and points to consider when you do estate planning at the very beginning.